Okay, within half an hour. Well, for Mr. Shamila, I don't think there's anything to be said. You're just a bystander and hoping to get some clarification on the side. Am I correct?
Yes, lady.
So that means this matter will then take us into, at most, 2 hours. So 2 hours is the time frame, and we'll stick to it so that we could be out of here and we can deal with what we have to deal with for the rest of the day. Right, Mr. Chekhov, the floor is yours.
Thank you, Lady. Lady, I trust that you have received our heads of argument.
I have.
May I also assume that you've read it, or should I not make that such an assumption?
What do you think, Mr. Chekhov, at this time of the year, or this time of the term? Let's say that. I have had an opportunity to read it, but of course I would understand that you want to point a few aspects out to me that I need to take heed of.
As your ladyship pleases. I will address the issues in the sequence in which they are addressed in the heads of argument. I won't repeat simply what is set out there, but I would like to elaborate on some, but not all of them. I start with the standard of review, which is addressed from page 4 of our heads of argument. Our heads are at case lines 151-3. I'm now at -6. The court held, we submit with respect correctly, that the test which we have labeled the Becker test is the appropriate test for review in this case. And we submit with respect that that was correctly so. But we emphasize that the Becker test not only sets 2 requirements for review. Firstly, that the expert's determination is not done as a reasonable person would have done. And secondly, that the outcome is patently inequitable. Those the court rightly held were the 2 essential requirements for that standard of review. But there's another aspect of that standard which I just wish to emphasize, as this court also correctly held, and that is that when it applies, it is the only standard of review. And this court made it clear in the paragraph 58 that we quote in our heads, paragraph 2, which says, therefore, for Makate to succeed with a review of the determination, he must show. In other words, that is a necessary requirement for any review. And the court also made it clear in paragraph 54 of its judgment, where it said that the decision is only reviewable if those 2 requirements are satisfied. So that the court held, we submit correctly, that the Becker test is the only available ground for review. And that, my lady, accords with the jurisprudence of the Supreme Court of Appeal. We quote in our heads on page 4 in paragraph 3 from the very recent judgment of the Supreme Court of Appeal. In fact, the judgment was delivered since we argued this case before you, in the case of Tahilran, where the court again considered the standard of review of an expert valuer, upheld what we call the Becker test, and then said the following in the last 3 lines on that page. The judicial ambit of the court's...
Jy kan dit sommer direk na haar toe betaal of na my toe, dit maak nie saak nie, maar laat ek net eers na prys kry dan ek weet ek ja, dan gaan.
So who's got their mic on? Khumutso?
Judge, it showed, I think it was Velma that it showed an eye. I don't know whose eye there.
Just mute all those people. Get them off the platform if they're going to be interrupting.
Okay, Judge.
Lady, as appears from that quote, the SCA recently said the judicial ambit of the court's power to interfere is severely circumscribed and limited to the narrow grounds as enunciated in this court's jurisprudence to which I have referred. In other words, making the point again, not only that the Becker test is the applicable standard, but that it is the only available standard for the review of an expert valuer's valuation. Now, learned friends argue now that the parties' agreement in some way broadened or departed from the Becker test, but that is not correct. It certainly was never pleaded, but we quote the agreement at the top of page 5 of our heads in paragraph 4, where the agreement was that the CEO had to act in an objective manner, relying on his experience and applying his mind fairly and reasonably, so as to ensure that his determination neither results in a manifestly unjust or patently inequitable outcome. It is a recital of the Becker test. The first part is that he must apply his mind fairly and reasonably. It speaks about the manner in which he has to make his adjudication, not the process. It says nothing about a procedure. It says he must apply his mind as a fair and reasonable person would. That's Becker part 1. And then secondly, so as not to result in a manifestly unjust or a patently inequitable outcome. That is Becker part 2. So the parties' agreement did not in any way depart from or qualify as Becker. So this court correctly held that the only available test, the Becker test, requires one to ask 2 questions. The first is whether not merely whether the CEO was wrong, but whether he made errors such as no reasonable person would do. And then secondly, whether the outcome, in this case the 47 million rands, whether the outcome was patently inequitable. So that is the only available test for this review. Now, it is fatal to Mr. Makate's case because in the first place, he never pleaded compliance with the second leg of the review. He never pleaded that the outcome, the 47 million, was patently inequitable. And for that reason, his pleadings, his founding affidavit and his supplementary founding affidavit did not raise the issue and did not make a cause of action. Once that is so, the application is fatally flawed, and we submit with respect that the application ought to have been dismissed simply on the basis, in the first place, that it did not plead a lawful cause of action, did not disclose a cause of action. It led on to the second, what we submit was oversight in this case. Because it wasn't pleaded, the court also never applied the Becker test. The court inquired into the correctness or otherwise of the various findings made by the CEO. But the Becker test requires one at the end of the day to say, is the outcome, the 47 million rands, is that a patently inequitable outcome? And that is a proposition that was never pleaded. And because it was never pleaded, it was not a proposition that the court ever entertained, whether the outcome was patently inequitable. In other words, whether the second leg of the Becker test was satisfied in this case. And with respect, my lady, we submit that if we are correct in those submissions, then that really should have been the end of the case and would be sufficient ground if these submissions are at least reasonably arguable, then they constitute sufficient reason for leave to appeal. But, my lord, the court also went further, and we submit with the greatest of respect, mistakenly so. At the behest of the Makate side, the court from time to time upheld administrative law grounds of review of the CEO's determination. And in fact, it expressly articulated that it scrutinized his review on the basis of a number of rules of administrative law review. We recite those rules in our heads of argument in paragraph 10. where the court made it plain that it would also judge his award by these standards. For instance, that he had to follow a fair procedure, that he had to have regard to the fundamental principles of justice, that one bad reason is fatal to the decision, and that he may not raise fresh justification after the event. Those are rules of administrative law. They are excluded and inapplicable by the Becker test, because the Becker test, as I've submitted, is not only a prescription of what is required for the review, but it also excludes any other ground of review. And the court from time to time then also foot-faulted the CEO on the basis of those administrative law grounds of review. We submit with the greatest of respect, incorrectly so. And then the court from time to time, or for the most part, when it considered the review, it applied an even lighter test, what we have called the appeal test. And that is simply the court simply inquired into the correctness or otherwise of the CEO's determination. And on a range of issues, held that he was wrong because the court had been persuaded that the answer he gave was not the correct answer to the question. And we submit with respect that that too is not the test. The question is not under the Becker test. The first question is not whether he's right or wrong. The first question is whether his finding is one that a reasonable person could have made. But one then has to add, the second question is the outcome, the result, the 47 million, patently inequitable. And the court went beyond that and applied different tests. If we then turn to the assessment of the CEO's determination, we have dealt with all the components of that assessment that are addressed in the court's judgment. And we deal with them one by one. We start at page 9 from paragraph 16 to deal with the duration of the revenue share on which the CEO based his calculation. And Milady, there seems to us to be a divergence between the approach of the CEO and the approach that the court thought he should have taken. But we submit with the greatest of respect that what is important in assessing his approach is to start off with the starting point that the parties prescribed to him. The parties said to him that what you must do is put yourself in the shoes of a CEO in 2001 and determine the reasonable compensation payable to Mr. Makate from that perspective, from the 2001 perspective. You may go forward to 2018 or to the present and look back to ensure that your assessment is a balanced one. But the looking back assessment is merely to assess whether the model postulated, i.e. the CEO sitting in 2001, is appropriately postulated. So the inquiry is not to determine after the event in 2020 what is fair compensation for the history of 18 years. The question is, looking at the transaction in 2001, looking forward, what would a CEO determine as reasonable compensation? And this is not theory. Remember, at the end of the day, the Constitutional Court held that the parties had agreed that the CEO would determine reasonable compensation. And that was in 2001. So the agreement was that the CEO would there and then in 2001 determine reasonable compensation. And the Constitutional Court ordered the CEO to go forth and give effect to that agreement. So not only did the parties agree that the CEO should put himself in the chair in 2001 and look forward, but that was also a necessary and inevitable implication of their agreement, which the Constitutional Court said they had to implement. Now, once one accepts that the CEO correctly put himself in the shoes of the 2001 CEO and looked forward, this CEO says, I have intimate expert knowledge of the arrangements between Vodacom and its service providers. I can tell you that the typical arrangement we have with service providers is a contract for a period of 1 or 3 or at most 5 years. Normally for a new untested idea, it would be no more than 3. But in Mr. Makate's favor, I would assume a contract of 5 years. Now, we submit with respect that that was an entirely reasonable and appropriate execution of his mandate, which required him to sit in 2001 and to look forward and to make an assessment on the basis of what was typically the arrangements with service providers like him. The court found that he was wrong on 3 bases. The first was that there was a self-find contract made in 2003, which was still running after 17 years at the time of this debate. But with the greatest of respect, the self-find contract is a contract after 2001 and is an example of a contract which endured for an exceptional period of time. It wasn't before the CEO, by the way. It was only produced after the event. But it was a contract that endured for an exceptional period of time. And we submit with respect that that was not the benchmark of the CEO. His benchmark was, what would the CEO sitting in 2001 have assessed to be reasonable, i.e. a typical arrangement with a typical service provider. There is the evidence of Mr. Hendricks, to which the court referred, but Mr. Hendricks merely spoke about the advertising earned on the back of the PCM product in 2012. And we submit with respect that that might suggest that the PCM has turned out to be a profitable product. But that is irrelevant to the perspective of the CEO sitting in the chair in 2001. And then the court added that the CEO gave further reasons for his decision in his explanatory affidavit. But with the greatest of respect, his explanatory affidavit was merely a response to the attack on his decision. He didn't raise new reasons or justifications. He merely gave an explanation of how the determination was made in the first place. And the criticism that, or the point that a decision maker may not raise subsequent justification. That's an administrative law point. And the effect of the point is to disqualify the new reasons, not to invalidate the decision. So we submit with respect that the CEO's determination of the duration of the revenue share was an entirely reasonable one and within the terms of his mandate. We deal with the court's criticism of him for his introduction of new revenue share models. We submit with respect that that's entirely appropriate for an expert with his mandate, but we do not elaborate on it for purposes of our oral submissions. There's his consideration of the employer-employee model, but we submit with respect that to criticize him for it was not appropriate. And that is so for the following reasons. Firstly, the CEO merely considered the model. He didn't base his conclusion on it at all. It ultimately had no effect at all. And it would have been improper for him not to consider it, having been the model placed before him by Vodacom. The rejection of the relevance of the model we also submit with respect is not correct, because the court accepted Mr. Makate's submission that the model doesn't get out of the starting blocks because Mr. Makate didn't have this brilliant idea in the course and scope of his employment. He was an accountant and not an engineer. But the evidence of the employer-employee model is not in any way confined to the compensation employers pay to employees for the ideas generated in the course and scope of their employment. On the contrary, the evidence makes it clear that it is evidence of compensation generally paid by employers to employees for their brilliant ideas from which their company, their employer, profits. And that is so from the messenger to the CEO. So it was entirely applicable. I'm not suggesting the CEO should have adopted it, but to criticize him for considering it is, with respect, unfair. There's the manner in which he dealt with interest. The court was under the impression that he'd made mistakes, and we deal with it with the greatest of respect. He was not mistaken. He clearly distinguished between interest and the time value of money, and never confused the two, as Mr. Makate had suggested. But we have nothing further to add to what we set out in our paragraphs 26 through to 31. There was Vodacom's production of documents, and on this score there is a contradiction in the judgment, in the sense that the court initially emphatically rejected Mr. Makate's complaint of inadequate disclosure, but then later made quite serious findings against Vodacom for not disclosing all the relevant information at its disposal. We submit with respect that that finding was not only contrary to its earlier rejection of the Makate complaint, but it was a finding which was not justified by the evidence. We know that there was much debate on the papers. I wonder, my learned friend, Mr. Pakran's picture is on screen, and we can see him very animatedly enjoying my argument, but I wonder whether he shouldn't mute his picture.
Mr. Pakran? Mr. Pakran?
My lady, I have unmuted. I have taken cognizance of my learned friend's criticism. He shall not see my face again until I...
Please, you're distracting his argument. Thank you.
Thank you, Mr. Pakran. Thank you, Madam.
It's easily distractible.
Yeah.
Yes, Mr.
So, my lord, on the production, my lady, on the production of documents, the issue is much debated and much disputed. It's not there's no point in rehashing those disputes. But under the Plascon evidence rule, we submit with respect, you couldn't find on the disputed evidence that Vodacom's discovery had been inadequate. Then there is another big issue. It's the so-called success rate. We deal with it from paragraph 36 of our heads of argument. And let me just elaborate, because it does seem to us that there has been a misunderstanding. There was firstly Mr. Makate's contention. Well, let me say, the starting point is this. We know that not all PCMs trigger return calls. So the first question was, how many of the PCMs triggered return calls? Mr. Makate proposed that it be assumed that all return calls within an hour of a PCM were triggered by the PCM. And that was an assumption which Vodacom accepted. so that there was then agreement between the parties to assume that all the return calls within an hour were triggered by the PCM, and they calculated that percentage, and they discovered that 27% of PCMs triggered a response call within an hour. So, but that was the limit of that agreement. In other words, how many PCMs trigger a return call? And that agreement was set out, just to give you a reference, Mr. Makate's supplementary founding affidavit, page 016-45, paragraph 7.44.2, correctly describes that agreement as follows. He says, during oral submissions before the CEO, I submitted that I would accept that only calls made by a recipient of a PCM to the sender of the PCM within an hour of receiving the PCM would be calls induced by PCM. That was the 27% of all PCMs. But once having determined how many return calls are triggered by a PCM, there is a further question, and that is to determine the incremental revenue. Because, explained the CEO, and Mr. Makate accepted, I will show you, that you can't necessarily accept that every call responding to a PCM yields any additional revenue. And let me give two very simple examples. The one is of a caller who has who has a contract. The contract allows her 100 minutes per month at a fixed subscription fee. The caller makes sure that she remains within the 100 minutes per month and never exceeds it. Then it doesn't matter how many of those calls are return calls, but Vodacom doesn't earn any incremental income from the return calls made within that quota of 100 minutes. So that would be an example where there is a return call triggered, but no extra revenue. The same is true of somebody with a prepaid contract. There is someone, a typical subscriber, who has a budget of 30 rands a month, and she never exceeds the airtime that she buys for the 30 rands a month. Now, if she makes a return call, then it simply means that she makes fewer other calls in the month because she never spends more than 30 rands a month. And those are two examples of people who make the return calls, but where Vodacom doesn't earn any additional revenue. And the question then is, which part of the 27% generated additional revenue? And it was that question, which was a vexed question, and on which the CEO engaged with the parties at length. And I do wish to emphasize that that question was debated with them at length. And may I just give you 3 references of where that debate occurred, and then take you to 1 or 2 crucial parts of it. The debate occurred, all of this is in the Rule 53 record, and that's at case lines 130, firstly at page 1107, lines 6 to 22. Secondly, at page 1114, line 23 to page 1122, line 16. And then in the third place, at page 1262, line 16, to page 1264, line 18. And it is important because you will see in that debate, there was a thoroughgoing engagement by the CEO with the parties on how to determine the incremental revenue earned by those 27% of return calls. And Vodacom's position was that none of it has been shown to be incremental. But let me show you what the position was of Mr. Makate. At page at 130-1107, that's one of the references I gave you. I wonder if my learned friend could perhaps bring this page up. It's my learned friend, Ms. Raw, who is adept at these things. Could bring up page 130-1107. Now, if you go to line 6, could we scroll up to line 6? Oh, yes. That is my learned friend, Mr. Pucken, speaking. And he says the following. The next question you asked me is, would Mr. Makate be entitled to incremental revenue? And I assume the question is only incremental revenue. And as a matter of logic, of course, I think that must be correct. The difficulty is to calculate it. So he accepts he's only entitled to incremental revenue. And he says, but how does one calculate it? If you go down to line 15, he says the following, in line 15, at the end of that line, one would imagine the first thing one would do is to see whether the revenue jumped between February 2001, April, May, June 2001. That would be a very good measure of incremental revenue as a percentage of revenue. And one could do random checks during that first year to see that it remained constant as a proportion, A, of revenue and as a proportion of subscribers, neither with or without airtime. So he suggested that the way to do it is to see whether the voice revenue increased disproportionately to subscribers after introduction of PCM. And that is precisely what the CEO did. If I can take you to his report, his affidavit at 078-44.
Yes.
Below the middle of the page in paragraph 105. He says the following, as has already been pointed out, the determination of which calls would have been incremental and which would not is an extremely complex exercise which defies any exact computation. The best guide, in my view, was to utilize the mobile voice revenue information that Vodacom provided after the oral hearing and to take into account as well the average customer growth per year. In other words, he postulates that exercise that Mr. Pucken told him is the best guide to incremental revenue. Mm-hmm. In analyzing this information, I found that in the 5 years following the inception of PCM, the growth in mobile voice revenue was mainly due to the growth in new customers. And this is demonstrated if one takes the average base growth and multiplies it by the average voice revenue per user. My analysis reveals that Vodacom's growth in mobile voice revenue can be attributable to the increase in the customer base, which by extension is a result of the investment into the network and coverage. This demonstrates that Mr. Makate is incorrect in his assertion that the Vodacom's mobile voice revenue growth was substantially premised on the PCM product. Indeed, I could not find any significant increase which was demonstrably attributable to PCM over the period, and this led me to make the further assumption that only 30% of the 27% could genuinely qualify as incremental revenue. I was satisfied that in assessing the further 30%, I was conservative and hence generous to Mr. Makate. So he says, I took Mr. Pakran's suggestion. I made that analysis, but the analysis did not show any incremental growth in voice revenue at all. On the back of that, Vodacom's contention was you can't allow any of the 27% because none of it has been shown to be incremental. Makate, however, insisted that it should be 100%, despite the fact that there was no evidence that any of it was incremental. And if I can take you back to my learned friend's conclusion on the topic at 103-1263, at the foot of that page, line 22. My learned friend, having made his submissions that it was appropriate to allow 100% of the 27%, concluded as follows. Now, is this a perfect model? No. Is it a perfect calculation of the incremental revenue produced by PCM? No. But is it a fair proxy for what incremental revenue was produced by PCM, where you are using within an hour? We submit that it is a fair proxy for what is there. If it is, I'll demonstrate the best you have. That is Mr. Makate's submission. And so the CEO was faced with a submission of 100% on the one hand, 0% on the other. His best effort to find some measurable basis suggested that there was no incremental revenue, and he then allowed a guesstimate, a 30% of the 20% in favor of Mr. Makate. But we submit with respect that that was entirely justified in the circumstances. It was a guesstimate. It was the best he could do, but it was favorable to Mr. Makate. If he's to be faulted, then he shouldn't have allowed anything at all because there was no evidence of actual incremental revenue. The court came back to this issue late in its judgment under the heading of the CEO's further reduction, and that's the reduction by 70%, but it's the same issue, that he only allowed 30% of the 27%, and we submit with respect that that was justified. It was the issue of call duration. There's also a misunderstanding that the CEO, there was no evidence of the call duration of return calls responding to PCM. So the CEO based his calculation on the average duration of calls generally, which, with respect, was the best available basis for estimation of call duration. So the criticism of him, or the suggestion that he contradicted Vodacom on that score, was with respect not correct. There's the effective rate. That's the effective cost revenue derived from each call, on which there was a debate between Mr. Makate contended for a blend between contract and prepaid rates. The CEO explained why the blend was inappropriate, and that is because the contract rate, you pay not only for the call, but you also pay for other things, including a new handset, and therefore that the average rate for prepaid calls is a more appropriate rate. The court preferred Mr. Makate's blended rate, but without any explanation for its preference or engagement with the CEO's criticism of the rate. And then, my lady, the court's order is a reflection of what we submit were mistaken findings. And in any event, findings which were not yielded by the Becker test, but findings yielded by the admin law and appeal tests. And there's even the one instance where the court itself directed the CEO, in paragraph 2A of its order, it directed the CEO to base his calculation on a 20-year revenue share, despite the fact that the court's own finding was that it should have been an 18-year revenue share. In other words, there's a discrepancy between the court's own finding and the order it made. It also, in paragraph 3.3, ordered the CEO to adopt Mr. Makate's model 9A, despite severe criticism of the model with which the court never engaged. And lastly, the court directed that he should allow the full 27%, that's the 100% of the 27% of return calls as being incremental revenue. We submit with respect contrary to the evidence, and in any event on a basis which was not justified. Milady, we submit in the last instance that the appeal is one deserving of the SCA, and we ask therefore for a direction that leave to appeal be granted to the SCA with costs in the course of the appeal. Thank you, Milady.
Thank you, Pedro. Thank you to Stephanie. I really appreciate that. Mr. Puckman, you can grace us with your presence.
Thank you, Milady. Milady, might I respectfully inquire, as did my learned friend, whether you received our heads? They were in fact filed on Wednesday, but somehow got lost within the inner workings of the High Court, and I believe only reached your ladyship yesterday.
Well, I've just been sending notes to my registrar because I haven't had access to case lines because of the fact that I'm not linked onto case lines anymore. So I haven't had sight of your heads. So you're just going to have to guide me, and I'll try and get a copy of those heads from Khomutso after the matter has been heard.
Yes, Milady, of course I shall do so, but in doing so, I shall try and avoid simply reading the heads. They are there for you. I'll emphasize those aspects of the case which we believe require emphasis. Before I turn to the heads, there are a number of issues, 2 or 3, that I believe require emphasis because they have either been misstated by Vodacom or in fact glossed over. Perhaps the touchstone for any judgment relating to Mr. Makate's entitlement is, of course, the Constitutional Court order. And I'm going to take your ladyship to the Constitutional Court order because Vodacom's contention with respect is misleading. Vodacom's heads of argument, paragraph 147-8 and -9, I don't know if your ladyship has that. No, that's not it, I'm sorry. Para 147, sorry. Lady, what my learned friend in fact read out, I don't want to waste time now finding it in the heads, but they emphasize that the Constitutional Court order impelled the CEO to make a finding in relation to reasonable remuneration. That is how Vodacom distances itself from a share of revenue. It says a reasonable remuneration, and the CEO had a discretion as wide as a barn door. Now, with the greatest of respect, when our learned friends quote the Constitutional Court order and say that the CC ordered a reasonable remuneration, what one forgets is that that is not, in fact, with respect, the entire order. May I ask you to turn, and perhaps I'll ask my learned friends to turn up case lines 005-42.
That would be helpful. Thank you so much.
Do you have it? Do you have it? Yes. Does your ladyship have it before you on your screen?
No, it's not brought up on my screen.
We'll just get the IT sorted out.
Okay.
I'm sorry, my lady.
But continue.
When your ladyship sees it in printing, it'll be more stark. But paragraph, what the paragraph that our friends rely upon is 3B and 3C. Let me read to you the whole of paragraph 3. Paragraph 3 states as follows: the order of the Gauteng local division is set aside and replaced with the following order, and then there is an order in inverted commas. It is declared that Vodacom Proprietary Limited is bound by the agreement concluded by Mr. Kenneth and Nkosana Makate and Mr. Philip Geisler. So the declaration is that they are bound by this agreement. B, Vodacom is ordered to commence negotiations in good faith with Mr. Kenneth and Nkosana Makate for determining a reasonable compensation payable to him in terms of the agreement. And then C, in the event of the parties failing to agree on the reasonable compensation, the matter must be submitted to Vodacom's Chief Executive Officer for determination of the amount within a reasonable time. And Vodacom is ordered to pay the costs. Now, what our learned friends have done in the heads of argument, the application for leave to appeal, is to conflate little 3A to D, and they come up with a single phrase that the Chief Executive Officer has to determine reasonable compensation. But that reasonable compensation is like a rudderless ship, and the only way to correct its course is, in fact, to read in the entire order, which is in terms of the agreement. Of course it is. And just to complete that, the agreement is conveniently to be found at paragraph 5 of Justice Jafter's judgment, which we'll see if we can find for you, is at 0005-4. Did you have it?
I have it, but I'm...
My lady, did you in fact see the order? Did
Yes,
it come up?
The orders in my judgment, so I've got a hard copy of that of the
Yes.
order. So
Yes. I just want to read Justice Jafter's paragraph 5, which is, of course, where the definition of the agreement between Mr. Makate and Vodacom appears. Let me continue by reading it. I hope it will be there for your ladyship to read in print. Yes, it's page 4 of 42, that's right. Anyway, para 5. The applicant and Mr. Geisler negotiated. There we go. Does your ladyship have it now? No. I'm sorry, let me read. The applicant and Mr. Geisler negotiated and agreed that Vodacom would use the applicant's idea to develop a new product which would be put on trial for commercial viability. If the product was successful, then the applicant would be paid a share in the revenue generated by it. Although the applicant had indicated that he wanted 15% of the revenue, the parties deferred their negotiations on the amount to be paid to the applicant for a later date. May I interpolate here? The 15% clearly indicates that the parties could not agree on the percentage of share. And it was that which was deferred on the amount to be paid. There would have been no need for Justice Jafta to have referred to share in the revenue, nor would there have been any need for Justice Jafta to have referred to 15% of the revenue. And then I continue reading, however, they agreed that in the event of them failing to agree on the amount, Vodacom CEO would determine the amount. But again, the amount is the amount of the revenue which would be shared. Ergo, the percentile of revenue generated by the please call me. Your ladyship, I don't think you've had an opportunity to read it, but it is para 5, 0005-4.
Thank you.
Now, lady, everything flows from that in this case with respect. I mean, that is what the agreement was. That is what the CC determined that the CEO should decide and award. Not a question of employer-employee relations or the like. And it was that which, with respect, hobbled the negotiations between Vodacom and Mr. Makate for a number of years. So much then for what it is that Mr. Makate was entitled to and what the CEO had to determine. The CEO, of course, does not dispute that. In his award, he himself concedes that he has to, in fact, given the CEC's judgment, he has to determine a share of revenue. So there's no dispute between the CEO and Mr. Makate on what the CEO was called upon to determine. It was a share of revenue. I want to deal next with Becker's case. My learned friend very confidently, as he did indeed the hearing before your ladyship, alleged that Mr. Makate had not pleaded Becker's case. I assume what he meant by that was that we had not pleaded the constituents of the standard enunciated in Becker's case, right versus right and the like. It may be useful, my lady, and now I really am going to have to ask my IT colleagues to find the case for your ladyship. It's easy to quote Becker, and it's easy to look at the head note, which is virtually the only part of it which is in English. But if one digs a little deeper, you will see there's more to Becker's case with respect than simply what is found in the head note. Milady, I'm going to ask, does your ladyship now have Becker versus RSA factors before your ladyship?
Jesus. Yes, now I have it. Thank you.
I'm so pleased. Thank you, Milady. Milady, I'm not going to read anything other than English. Not that I'm suggesting that your ladyship wouldn't understand, but the head note, the translation of the head note as one used to, of course, get in the old days with the law reports, is what was taken up in Wright versus Wright in 2015. If a third person is nominated to fix a price or to make a valuation, he must exercise the judgment of a reasonable man. I agree with my learned friend, this is the first test. If he exercises his judgment in regard to the determination of the price or valuation so unreasonably, irregularly, or wrong that it would lead to a patently inequitable result. I want to interpolate there. I believe that the agreement between the parties and the CEO's understanding of his task it would lead to a patently inequitable result or a manifestly unfair decision. There are two concepts which, for the life of me, I really cannot distinguish between. One would imagine that a manifestly unfair result would be a patently inequitable result. But be that as it may, I continue reading from the head note. Then the person prejudiced thereby is not bound by it, and the determination or valuation can be rectified on equitable grounds. It's important. It's an equity judgment. You upset it on equitable grounds. Now, lady, where does this come from? I'm not going to try and read Potier and Foot, even with Gaines' translation. But if you would turn the page, when I say turn the page, I mean that figuratively these days, 151-49. Whence does His Lordship Justice Grosskopf derive these principles? He derives them first from the Roman Dutch law. He cites Potier, and then he cites Foot. But closer to home, he cites Justice Miller. Now that is Miller, M-I-L-L-E-R, who later, Milady, was elevated to the then appeal court. He cites, you will see, unfortunately I can't give your ladyship a line, but it's midway down the passage. If perhaps somebody will put a marker on it. He cites Dublin versus Dinah,
Yes.
1964, volume 1. Does your ladyship have
Yes,
that?
I see that.
And then I won't read what the case was about. I will simply cite what Miller J. decided. That if in the present case the respondent were able to show that the price determined by the auditors is so grossly excessive that it bears no reasonable relationship at all to the value of the shares at the relevant time, and it is a manifestly unjust and unfair price, he would be legally justified in refusing to pay the price now demanded by the applicant. And then what is important is that Justice Miller, and you will see with the approval of Grosskopf J, says that in the course of the judgment in Dublin, this is what Justice Miller said. And he cites none other than Lord Denning. In Dean versus Prince, 1954, 1 Chancery, at 426, Denning, Lord Justice, indicated the grounds upon which a determination of the value of shares by an auditor for purposes of fixing the purchase price of such shares could be impeached, and was of the opinion that it could be impeached not only for fraud, but also for mistake, e.g. if the auditor made an error in the addition of figures, for misdirection, for wrong interpretation of the agreement, and even if the court cannot point to the actual error, nevertheless, if the figure itself is so extravagantly large or so inadequately small that the only conclusion is that he must have gone wrong somewhere, then the court will interfere in much the same way as the Court of Appeal would interfere with an award of damages if it is a wholly erroneous estimate. And then says, and I'm not sure if this is Miller J or Groskopf J, I think it's Groskopf J, provided the extravagance or inadequacy of the determination is sufficiently gross, it seems to me that the passage I have quoted substantially reflects our law too, save that I would add that I should not be understood to suggest that circumstances which would justify interference on appeal in South Africa with the trial court's award of damages would necessarily also justify the setting aside of the determination, etc. Then, in total South Africa, Justice Friedman states the following, again quoted with approval by Justice Groskopf. In summary, the position would appear to be as follows. Where parties to a contract make provision for the valuation of the subject matter of the contract by a third party, neither party can be held to that valuation if it is the one that is so grossly, if it is one that is so grossly excessive, or in suitable cases so grossly less than the true value that bears no reasonable relationship at all to the true value of the property. And then he says the party in whose favor the valuation would appear to be cannot compel the other party to perform. So this adds color to what is, with respect to rather laconic test set out in Becker in the head note, which has been borrowed in Right versus Right, if I may use that phrase, and which the parties, with respect, in fact, introduced into their agreement during the hearing. In fact, it was Vodacom's counsel who elected to read into the record what he considered the test should be, and it was taken from Right versus Right. And of course, the CEO adopted it in his judgment. Now, the question then is, A, did we plead Becker versus Becker? And B, did we, with respect, demonstrate to the court that the determination or award of the CEO was so out of kilter with what one would expect that one could say it was unfairly prejudicial, and that it should therefore be set aside and could be avoided by my client, Mr. Makate. Now then, let me turn to the pleading point first. I said, and I repeat, I'm not sure that I'm reading the same record as my learned friend. Before we turn to what is an exception point, really, I know this is an application, but one would assume that if your ladyship were being asked to find that my client's founding papers, supplementary as well, were to be struck down for not disclosing a cause of action, it really is an exception. Now, let me just give you all the references. The first is I think paragraph 11. No, just up to 10. It is paragraph 10 of the founding, which your ladyship will find at 0035. 003-5. Now, lady, may I make this point, and why I have emphasized that this is an exception point? One assumes that the principles of the exception apply. In other words, I'm not asking your ladyship to find at this stage that what is stated in paragraph 10, which I say is an adequate pleading, I'm asking your ladyship to accept that what is stated there is correct purely for the purposes of assessing the exception. Now, what Mr. Makate says, I immediately appreciate that 47 million sounds like a significant sum of money, but it must be appreciated that it is in fact merely 0.023% of the 205 billion in core revenue that my team calculated that the PCM earned Vodacom from 2001 to 2020, excluding various revenue streams, to say nothing of the revenue that will continue to be earned by Vodacom from the PCM going forward. There is no sense in which an amount of 0.023% can be said to be a reasonable share of the revenue concerned, which can be up to 85%, as in other instances. That was self-fined. Now, lady, I must tell your ladyship that you will remember from the hearing that the computations became far more complex and far more accurate, and the gross revenue which Mr. Makate's team contended was earned by Vodacom by the time the matter was heard by your ladyship was an order of magnitude above 2 billion, at least 200 billion. And then just read paragraph 11. Now, having, with respect, in paragraph 10, pleaded what is partly required by Becker, we say it's completely out of kilter with what would be reasonable. We say, I contend that Mr. Joosub acted manifestly irregularly, unreasonably, irrationally, unfairly, unjustly, and inequitably. In other words, let's take a pick of the words, manifestly, inequitably. I'm just having an online dictionary demonstrated to me where a synonym for patently is manifestly. Yes, I'm not sure that my learned friend, Mr. Trengove, my good friend, Mr. Trengove, would ever stoop to this form of argument on the semantics. But we say that that is all that is required to plead yourself right into the Becker situation, the right versus right situation. And indeed, the wording is taken from the agreement which was struck with Vodacom during the hearing by my learned friend, Mr. Marcus and Mr. Solomon. And then there are 5 main issues. Milady, let me very briefly tell you, that's not the only passage that pleads Becker's case. Let me just quickly give your ladyship one. There are 11. Paragraph 57 of the founding papers at 003-28. And just to give your ladyship context, we're dealing here with the period, the duration of the contract. And we criticize the CEO's failure to consider revenue on an 18-year period, and that's at para 56. But in 57 we say, I submit that this is manifestly irregular, unreasonable, irrational, impermissible, unjust, and inequitable. Now, my lady, let's just consider that pleading for a moment and assume that your ladyship is with us on the duration of the contract. That's 4 times greater than the CEO allowed. I would with respect submit that in anyone's language, a factor of 4 times, or an understatement by a factor of 4 times, must surely be grossly irregular, unjust, and inequitable. It continues. At page 003-42, para 84, again, in para 84, we say, Mr. Joosub acted manifestly irregularly, etc. I'm just going to give your ladyship the references now. 003-49, paras 105 to 106. This is the question of interest, which the CEO conceded he had erroneously considered that I had abandoned. In this regard, Mr. Joosub acted manifestly irregularly, unreasonably, irrationally, unfairly, unjustly, and inequitably. Yet another passage. 003-51, there was the question of assessment of the contingency provisions, and at para 112, one finds again the chorus, Mr. Joosub acted manifestly, irregularly, unreasonably, etc. Yes, I think that's most of them. There are 1 or 2 others, but milady, I can go on and on and on. Supplementary founding affidavit 016-49. Perhaps your ladyship can make a note of para 7.64.6. So, milady, despite the bold submission that we did not plead Becker's case, I suppose if that were correct, my learned friend couldn't point to something that didn't exist, but he hasn't tried to explain why these 11 or 12 passages which seem to read directly onto Becker's case and the agreement that existed between the parties during the hearing don't suffice as a pleading for purposes of an application in a founding affidavit on review. There's nothing in the point. As my learned friend, Mr. Marcus, if I may plagiarize his argument, if that's the best you've got, the case must be weak with respect. Milady, let me try. I notice, Milady, I know your ladyship is now used to other tea times and the like, but it's 25 past. Could we have a break of 15 minutes?
Yes, we may, under the circumstances. Right, we'll take the tea adjournment at this stage, and we'll resume in 15 minutes.
Thank you, Milady.
Thank you.
Okay, let's try.
How are you? No, I was just speaking to Annabelle. She can admit me. Am I in? Let's see. Yeah, I'm back
How
in
did you
now.
thought they were going to use their
In fact, my
we'll start with the short adjournment, or are we on board at the moment? It says Mr. Puckrin.
Yes, I'm ready, my lady.
Right. I now have the pleasure of having, sorry, just to interrupt, I now have the pleasure of having printed your heads of argument, so you can take me through them when you come through.
Thank you, my lady. Thank you for that. My lady, let me then immediately page through what I've already dealt with. I would. Does your ladyship prefer me to refer to the case line pagination, or does the hard copy which your ladyship has not have case line pagination?
In terms of the heads of argument?
Yes.
It has the, it's 150-3 it starts at, is it not? Yeah, so,
Yes.
So I'll be on board.
So it's case line.
Yeah.
All right. My lady, I need not bother you with the first about 10 pages. I think that I have dealt with Becker's case. And then if I might just ask your ladyship to note page 150-13, paras 30 and following. Now, my lady, we say, and your ladyship found in the judgment, your ladyship obviously, I have a memory that your ladyship posed to Mr. Cooper when he was arguing, but was the 70%, 30%, ever debated with the parties? Mr. Cooper's answer, it was in the afternoon, I think of the first day, was clear. He said, we will scour the record, and if we find that we did not do so, well, then we will have to go back and do so. And the following day he returned, he was unable to show you, and my learned friend, Mr. Trengove, despite his best attempts, been unable to show where there's been any debate about the 70% and the 30%. The best that one can come up with is that there was a mention, Mr. Trengove exaggerated by saying there was debate hither and thither. There wasn't debate hither and thither. And in fact, it's quite clear if you look at the few references to incremental revenue that Mr. Makate's team, at least, were of the view that the incremental revenue meant the 27%, the window. There wasn't a meeting of minds, and this is cleared up in the replying affidavit, and I shall take you to that in due course. But with respect, insofar as the process was challenged, your ladyship did ask Mr. Cooper to tell your ladyship where the 70% came from. I certainly had absolutely no opportunity to debate the 70%. Vodacom and ourselves were agreed on 27% for the time window, if I may call it that, and we considered that to be the incremental revenue. My lady, there's one other aspect which is all-pervading and must place a large question mark over the CEO's figures and models and calculations. You will bear in mind that a highly qualified auditor, highly qualified accountant, Professor Weiner, gave evidence and explained that the fallacy in counting calls which had been paid for as revenue, but the calls had not been made, is that in terms of every international accounting standard, revenue only accrues when the call is made. When, in other words, the debt which Vodacom owes the consumer, be it a contract consumer or a pay-as-you-go consumer, the debt only accrues as revenue once the call is made. There was no answer to Mr. Weiner. Nobody gave, no expert came to give evidence to suggest that Professor Weiner was wrong. The CEO's explanatory affidavit, I'm not going to deal with that. With respect, your ladyship dealt with it, and we support your ladyship's findings on the fact that there were ex post facto rationalization in the CEO's reasons. The CEO's models, I see that from paragraphs 48, 49, 50, 51, I've already dealt with that, although I elevated that to the first argument which I delivered, and that was the concept of reasonable remuneration. Reasonable remuneration in terms of the contract between the parties, yes. You will remember that the 5% was accepted by the CEO, patently so, in his award, and it was not disputed by Vodacom. Now, of course, once you've decided on an alibi defense, and your alibi defense is destroyed, you are up the creek without a paddle. Now, Vodacom, clinging tenaciously to their employer-employee model for remuneration and ignoring the agreement between the parties, really had no room for arguing a percentage. They might have done so in the alternative, but they were too recalcitrant to do that. And we say in 54, Mr. Makate abandoned the 15%, and we did. The CEO applied a revenue share of 5% as agreed. In 56, I've already dealt with, that's the order. Now, 7.3 is important. I would ask you just to read it. I'm not going to read it out. Para 61, 62 deal with employer-employee relationship. Yes, the leave to appeal 8.1 is clearly wrong, and we leave your ladyship to read that. The fact that the Constitutional Court did not wish to hear us on an interpretation of the order, there are myriad reasons why they may have done that. We say that they have absolutely precedential value. I'm sorry, my lady, I know this is painful, but because your ladyship has not had an opportunity to see them, I'm just trying to point out where certain aspects are dealt with. Yes, para 75 again is to deals with the revenue share. It wasn't just reasonable remuneration, it was reasonable revenue share. Now, the duration of revenue share. My lady, this, with respect, does not redound to the CEO's a credit. The CEO, when questioned about the agreements which he said he had regard to for other service providers in the position of Mr. Makate, said that he had no regard to written contracts, but simply used, I suppose the best one could say is he used his memory of them. Now, lady, in our learned friend's criticism of your ladyship's judgment, and in the heads of argument, and of course in the CEO's reasons, he suggests that he would never, looking forward, have granted a contract for more than 3 years. And he says 5 years is generous. Now, there's one figure you do not have before your ladyship, but for sell fine. You do not know what any of these other agreements, which the CEO allegedly had regard to, you do not know what any of them earned Vodacom. No figures have been placed on them. In Cellfind, we know for a period of 4 or 5 years, there was, I think, a couple of 100 million. But there is nothing on these papers to suggest that any of these other services, be they VAS, WASP, or whatever, have earned the billions that Please Call Me has. Now that in itself, I suppose, is a sort of benchmark for the period which Vodacom might have agreed upon. Now, lady, with respect, can we just analyze the probabilities, and can we analyze the way that commercial men and women regulate their affairs? Yes, we understand, and it is recorded in the Geisler-Makate agreement, that we will test your idea technically. If it works technically, we shall take it to the market. It's common cause that technically it was tested within 6 weeks and proven to be entirely viable. By April of the following year, it had already been launched, and you saw the glowing report of Mr. Ntembu, the then managing director, about this wonderful new service. It took off with respect like a rocket. And what would probably have happened, I would suggest, and what Mr. Joosub would have done, or Mr. Not Craig, is to say, look, let us enter into an agreement for, say, 3 years. And let us assess what this is doing for us in 3 years. But here Vodacom wants the following: cake and eat it. Vodacom says, I will pay you, we would probably have paid you a share of revenue for 3 years. Let's make it generous. We'll give you 5 years. But by the way, we're going to continue using your idea. And we're going to earn billions. And that, if anything is grossly unfair, if anything is patently unfair, it is that. You take a man's idea, you pay him for 3 years, and you use it for now 21 years. That's patently unfair. And that would warrant this being sent back on its own. Why is it patently unjust? Because it's inflated Vodacom's share by 400%, with a correlative reduction in Mr. Makate's share. This is what we state in paragraph 10. Just urge your ladyship to read it. Now, lady, it is in your ladyship's experience, obviously, sometimes to have regard to what a party does not argue, as it is important to have regard to what it does argue. Please call me Count. Our learned friends have assiduously avoided dealing with in the application for leave to appeal because there is no answer. Mr. Cooper had no answer to it, and other than to try and denigrate the exercise which the CEO had done in paragraph 6.4. But lady, may I just remind you about this, because with respect, if we are correct, and we patently are correct, then the CEO has again been manifestly unfair. If I may ask your ladyship, chaps, you're going to have to help, to have regard to the CEO's judgment. I've got it. Your ladyship will remember that at 004-8, lady, paragraph 6.3, 004-8. The context is that Mr. Graham Anderson, who was the CEO's, I think, on my calling PA, called upon Vodacom to supply certain figures. They wanted total figures for voice revenue. This was after the hearing, and Vodacom supplied certain documentation. Now, what I would like to read 6.3. I draw attention to fundamental aspects of Model 8A, and in particular the calculations of voice revenue on which the model is based. I point out that those basic estimates need to be carefully examined, because if they are inconsistent with the publicly available financial data, the model would be discredited. So he's talking about publicly available financial data. Now in 6.4, there is either a gross error on the part of the CEO, or, and I would hate to even suggest it, something has been hidden by Vodacom because they haven't given the CEO the total figures. He says, I have contrasted those figures with the financial information provided by Vodacom showing its voice revenue. Now he defines what he's been given, i.e. the income generated when a Vodacom mobile customer receives a call from a user on Vodacom or another fixed or mobile network. I'll pause there. He's clearly talking about all voice revenue from a Vodacom to a mobile customer, because he says receives a call from a user, either contract or pay-as-you-go on Vodacom or another fixed or mobile network. Your ladyship knows about what's called MTR. It's the mobile termination rate. That's how the cell phone companies pay each other for the use of their termination equipment. There's no doubt that that is part of voice revenue. And then what he says is, as appears from these comparisons, the percentage portion of the voice revenue that Makate attributes to PCM alone is shown in column 4. And he sets out to discredit Mr. Makate's model. Why he'd want to do that, I don't know. by leaving out about 60% of total voice revenue. He leaves out all contract and he leaves out MTR, having in the preceding paragraph defined them as forming part of the total voice revenue. Can that be said to be just? Quite clearly, manifestly unjust. And of course, once you skew the figures, it makes Mr. Makate's case appear ridiculous because, frankly, if you look at column 4, it suggests that 97% of total mobile voice revenue, his language, column 3, total mobile voice revenue, he says 97% of that is attributable to Please Call Me. Of course, that's ridiculous. And anyone reading that would consider that Mr. Makate's model is entirely discredited. And that's what he says in 6.5. Just look at the concluding sentence of 6.5. The numbers resulting from the model are unrealistic, and on this ground alone, one cannot place reliance on Model 8A. If one considers what Lord Denning said in the Peace case, with respect, your ladyship need not know how this error came about, whether it was Vodacom's fault for feeding the CEO incomplete information, or whether the CEO deliberately excluded it. But one thing is for certain, your ladyship knows that those figures are wrong. We made the point in the affidavits, and there was no answer. There was just no answer. Now, in 6.6, my learned friend, Mr. Trengove, suggests that the exercise that the CEO did in 6.6 through to 6.8 were at my suggestion to calculate incremental revenue. Well, you just have to read 6.6 to 6.8 to appreciate that that is not so. It was an ingenious attempt, but I can't take credit for what he did here. The first thing that one notices is that he's comparing apples with pears. His table 2 deals with customer growth and total revenue SA. Now, of course, the total revenue, let's look at the asterisk, which is at 004-10. Total revenue includes revenue from voice, data, equipment sales, SMS, interconnect, and other value-added services. What does this tell us about incremental revenue? We have no idea how much of that is made up by total voice revenue. It is just meaningless. It's fluff. It's absolute fluff, with respect, in order to confuse the issues. So, milady, where are we at the moment?
Yes.
We're at and I want to complete this. We're at a situation where we say we've pleaded Becker's case. We explain that Becker's case requires either a patent unfairness or whatever you want to call it. We've demonstrated, one, we say, a fourfold reduction in Mr. Makate's share because of the duration. Secondly, we have demonstrated that the CEO has understated the total voice revenue to discredit Mr. Makate's workings by 60%. All of this, of course, was canvassed in the review, and I'm not going to take you to the actual passages. We don't want to re-argue this matter, as you said. Incremental revenue. Well, you only have to look at Professor Wayner's affidavit, and I'll give you the reference before I sit down.
Are you standing, Mr. Butler?
Yes, it's 119.62. That gives you the Professor Wayner's, the footnote gives you Professor Wayner's affidavit.
Thank you.
I've done the question of duration, the share of revenue. I really can't believe that Vodacom are debating that. Interest, we have the, with respect, the say-so of the CEO himself.
I think you've covered everything now, Mr. Patron, is it not?
I think I have.
But there's just one aspect that I just want to engage with you. That was brought up by Mr. Trengrove in the beginning of his argument. The fact that this review is bound to the Becker test means that the court should not have had any regard to administrative review rules or the administrative law issues when dealing with this review. And thus, the court erred in doing so in this review. Give me your response in respect of that argument that Mr. Trengrove advanced this morning.
Lady, that's easy. With respect, there must clearly, if you look at the Becker test, there must clearly be, to a certain extent, an overlap between what he calls administrative rules, we call just rules of equity, rules of natural justice. There must be an overlap. And we've cited two in our heads. I'm sorry, I perhaps should have pointed them out. We've cited two SCA judgments which make that point.
It's just point me to them, please.
We'll put them up. No, I won't put them up. We'll just give your ladyship the references.
In the heads.
It's in the heads.
Yeah, just give me the page ref because I haven't had a chance to read them. So give me the page ref so I could just mark it.
Yes, I'm sorry. I'm receiving Morse code signals here. I never was much of a signaller in the army. 150-11.
150-11. Yes, I'm here.
It's para 24.
Yes, I thought as much. Yes. Okay.
You know, lady, once the Becker test says, and once one investigates the substratum of the Becker test, you realize that if a result is inequitable, be it in administrative law or be it with respect for a valuer or for an auditor or for the CEO or a deadlock breaker, the law surely should not adopt a non-posthumous attitude. And that's the answer to my learned friend. There's no rigid dichotomy, we say, between administrative law principles when they deal with justice and fairness, equity, and the Becker test. Yes, and could I just refer you to 138-5, para 4.4.
138.
138-5, para 4.4.
Mr. Marcus's argument.
It's a quotation from Baxter. Well, it refers to Baxter. Lady, can I just add one thing? And that is, it's all very well for my learned friend to say that your ladyship applied administrative law rules, but your ladyship certainly applied the Becker test. In addition, it may well be, this is not my primary argument, I say that there's an overlap, but it may well be that the CEO, in fact, was guilty of an infraction of both. Lady, this is not a plea in misericordia. This is a hard fact. Something else that has been inequitable throughout all of this is the delay. And one can't ignore it, with the greatest of respect, when one is dealing with an inequitable result, an inequitable conduct. One cannot ignore the delay. To prolong this with respect it would be to shortchange Mr. Makate on his day in court. Let the CEO go back and let him correct his patent errors, and let us see what comes out. May it please your ladyship. Thank you so much, Mr. Milady, may I just say this? We are so sorry that the heads were missing, because that's delayed us. My learned friend, Mr. Micho, had prepared a couple of points of argument. Could you grant us that indulgence?
Mr. Mika, how long are you going to be? Because I can only give you a few minutes up until 12:30, and that's the end.
2 minutes, he says, lady.
Come through, Mr. Mika.
You're going to take that. Sorry, my lady, I'm somewhat immobile at the moment.
Okay.
Just give me your hand.
Thank you, my lady, and good morning. I'm literally going to be 2 minutes. I've got to justify my existence here on some other basis. My lady, your ladyship will recall that I dealt with the boring factual issues of the model and the numbers, and there are just two issues in our learned friend's end of argument that I want to give your ladyship references to. Because as a general rule, your ladyship knows how reluctant courts of appeal are to interfere with findings of fact made by the court or quo. But just let me give you two references, my lady. Your ladyship will recall that Mr. Trengrove said to your ladyship that this has to deal with the call duration, and that there was no attempt even to calculate what the average call duration was. Well, my lady, with respect to my learned friend, that's not correct. Your ladyship needn't go there, but you can just make the following reference on case lines 006-455. That, my lady, is where the SNG report and the figures at that mining, data mining and figures verified by Vodacom. And in there, on that page, you will find the call duration of the return calls from PCM in seconds. For 4 different types, for unknown, prepaid, contract, and hybrid. And every single one of them is longer than 2 minutes. Your ladyship will recall initially, Makate said 6.8 minutes. The CEO said less than 2 minutes. And it's on that basis that we said, well, let's avoid that fundamental dispute, and we'll stick by his version of 2 minutes. But in fact, even on the factual findings, it is longer than 2 minutes. The other thing that I wanted to point out to your ladyship is this, and that is the debate by what my learned friend Mr. Trengrove once now again said, that dealing with the blended effective rate and how the contract also includes the hard equipment, the telephone, the cell phones, and the like. But if your ladyship goes to page 130-1571, and that is just an example of the annual financial statements of Vodacom, and your ladyship will see that hardware is a completely separate item, and it's the revenue is divided into voice revenue, a host of other things, but certainly the hardware and the cell phones are completely different. It is on that basis, your ladyship will recall, that we said the best way to do it then is to blend the effective rate. It's a combination between prepaid and contract, but certainly the evidence was that the hardware in any event is a separate line item. Last point, my lady, because the one thing that I see, that although raised in the application for leave to appeal, the number of PCMs sent was a debate. It was a ground for leave to appeal, but wisely our learned friend seems not to have persisted in their heads of argument with the number of PCMs sent. Well, that, my lady, with respect, already puts this as patently inequitable, call it what you will, because the number of PCMs sent, as demonstrated by Mr. Makate in the evidence, was far higher than what the CEOs were. And that ground of appeal is no longer pursued. So that on its own, and together with the other things that Mr. Buttran had mentioned with respect, that's the end of the patently unjust argument so strongly pushed by our learned friends. Lady, the one last point is this, paragraph 49 of our learned friends' heads of argument, and that deals with the ICASA rate. And my learned friend says there, but what happens if Vodacom charges are in fact less than ICASA, the ICASA published rate? But with respect, my lady, our learned friend has not understood the ICASA rate, because ICASA gets its rates from Vodacom, and those are the figures that Vodacom gives it, and it's those figures that are published. So it's not a rate independently made up by Vodacom. In fact, it's the figures given by Vodacom to ICASA, which ICASA then publishes. So there's no merit in paragraphs 49 and 50 of the heads of argument of Vodacom. My lady, I'm going to be for once true to my word and finish in less than my allocated time. Thanks, my lady. And those are the only submissions that I wanted to make.
Thank you, Mr. Mika. Mr. Cooper? Just let me deal with Mr. Cooper before you go through Mr. Trengrove. Mr. Cooper?
Lady, the point that we ask for clarification is simply in paragraph 7 of your ladyship's order. Your ladyship clearly had in mind against which parties or party this would operate, and we would simply ask that your ladyship supplement prayer 7 so that the position is clear. Thank you.
Mr. Cooper, I just want to point you to paragraph 53 at page 19 of my judgment, the last sentence, which reads, "It is these factors that fortify my view that the CEO performed the function of an expert valuer." So in these circumstances, it's clear that the CEO was an expert. I mean, there's in no uncertain terms, no expert is saddled with costs.
Yes. No, that is so, my lady. But as your ladyship will well understand, unless it's spelled out in words of one syllable, our learned friends are going to come hunting for us. So we need protection. Thank you, my lady.
Thank you, Mr. Cooper. Mr. Pendo?
Thank you, my lady. I won't be long. May I just say this at the outset? The question is, what are the issues before you today? We submit with respect. The question is whether there's a reasonable prospect that another court might overturn the judgment. And that engages primarily not only the conclusions of this court, but also the basis upon which it came to those conclusions. Now, our learned friends, in a number of respects, re-argue the case. They say, in effect, over and above the reasons taken into account by this court, there are other reasons to come to the same conclusions. Now, I appreciate that, at least in theory, one can support a judgment for reasons beyond the judgment itself. But that, with respect, would mean just a re-argument of both sides of the case. And that is quite inappropriate in a case like this. What is appropriate is to look at the judgment, to look at its conclusions, to look at the reasons for those conclusions, and judge on that basis whether another court may come to a different conclusion. And that's the appropriate basis we submit, rather than to re-argue the issues beyond those considered in the judgment itself.
Mr. Treasurer, before you just continue, so that whilst it's on my mind, the case reference on page 4 of your heads,
Lady.
Teleron 1, is it you've only made mention of paragraph 27, is that correct?
Let me just check.
The Lucumber trustees case that you made reference of the SCA. I've tried to go through it, and I see that, well, as quickly as I could, I see that the paragraph 27 just alludes to the fact of the duties of an expert valuer and when his duties end and when it begins. Where in the judgment does it deal with the aspect of the Becker test and only the Becker test and not administrative rules? I see Mayor AJA does mention something about he's referred to jurisprudence, which I referred to, so it would be within the judgment. Can you just point me to that quickly so that it's not going to waste my time when I need to deal with this aspect?
Melanie, may we let you know after the hearing? I don't have the whole judgment in front of me, but we will do so.
Thank you so much. Right.
But we
I've got that out the way. Thank you.
Thank you, Melanie. Let me say, though, that the Becker test, in its essence, is an exclusive test. The Becker test itself says that if you want to overturn a determination by a valuer, then you have to show two things. Firstly, that his findings are not those of a reasonable person, and secondly, that the outcome is a patently inequitable result. And it can't mean you have to show these two things, or you can also show other things. The very essence of the test is that there is only one benchmark for the review of an expert valuation, and that is the Becker test. And Melanie, this court held that to be so. Paragraphs 54 and 58 of its judgment, both paragraph 54 says that such an award may only be reviewed on this one ground, may only be reviewed on this ground. Paragraph 58 said that in such a review, the applicant must show these requirements, so that the essence of the test and this court's finding of the applicability of the test both necessarily imply that this is the only basis on which you can review the award of a valuer.
And what about the issue of Mr. Puckrin's, that it's basically also it's overlaps between the Becker test and the rules of natural justice? What about that argument?
No, with respect, there is absolutely no foundation for that argument at all. It's incompatible with the Becker test line of cases. And the cases that they invoke for a departure from Becker do not support them. They refer to the SAB case. That's the only case which suggests a different test. That's SAB v. ShopRite. That's one of the cases they refer to. They rely on paragraph 22. But that case was a contractual dispute. The contract says that such disputes must be referred to an accountant for determination of the dispute. And the court then said, is that accountant an arbitrator or is he a referee? And then it said it's sometimes not clear, but the same rules that apply to an arbitrator also apply to a referee. The sentence on which they rely is paragraph 22 that says, counsel on both sides were agreed that in general, the requirements for a valid arbitral award are equally applicable to an expert determination, and we were referred to a number of authorities which these requirements are set out. And then they refer to all the building contract, arbitration, dispute authorities.
Yes.
And the difference is this. Remember, our courts have said that an arbitrator performs a quasi-judicial function because he determines disputes. That is judge-like function. And for that reason, the rules of natural justice apply when an arbitrator performs that function. Mm. In the same way, a referee, where parties in a contract says, where we have any dispute between us of an accounting nature, will be referred to an accountant for determination of the dispute. Then the accountant performs a quasi-judicial function. And then you can understand that the same rules that apply to an arbitration applies to the accountant. But that's the very difference of an expert valuer. He doesn't determine a dispute. His job is to complete the party's contract by determining a price for them. And that was what the Constitutional Court held to be so. That is when Becker kicks in. When he doesn't perform a quasi-judicial function, they entrust to him the function of determining the contract price. That is when Becker kicks in and says, by the agreement of the parties, that expert has a wide discretion. He can do it in whatever way he deems appropriate. He may hear the parties or not hear the parties. He can draw on his own information. He can find his own information. And you can overturn him only if you satisfy the Becker test. So unreasonable as to no reasonable man would have done. And secondly, patently inequitable. The outcome, patently inequitable. And so that we submit with respect that to refer to a case of a referee under a building contract or a commercial contract is just has nothing to do with the Becker test at all. Our learned friend says they pleaded Becker, and they refer you to a number of paragraphs in their founding affidavit in which it was said that certain determinations made by the CEO were unfair, unreasonable, and he has a string of adjectives. And he's quite correct. I'm not going to take the point that patently isn't in there. But the point is this. What they did is that they applied what we would call the first leg of Becker. And that is to say, this finding was wrong, that finding was wrong, and unfair, and patently wrong, and patently, etc., etc. They picked on individual findings, criticized those findings, and said they were not only wrong, they were unfair, and so on and so on. But that's the first leg of Becker. That is to say, he made findings such as no reasonable man would have done. The second leg of Becker requires one to look at the outcome, requires one to step back and say to yourself, well, whether whether he made mistakes along the way, can I say that the outcome is patently inequitable? And for that, in this case, one has to step back and say, is 47 million rands a patently inequitable reward for a brilliant idea? And that is the exercise that they didn't plead and the court didn't do, and with respect, without which the Becker test just isn't satisfied. So it is no good to say that under the first leg of Becker, we criticized lots of his findings, unless you also step back at the end of the day and say the outcome, 47 million. Why is 47 million a patently inequitable reward for a brilliant idea of an employee? All the other precedents we have of rewards by Vodacom and its peers of brilliant ideas contributed by their employees pay them awards from 500,000 rands to 21 million rands. That's the upper limit, upper range. Why, if that is the going rate for rewards of employees who come up with brilliant ideas, why is 47 million patently inequitable? And I'm not saying that there isn't room for debate. There is room for debate, but that issue was not pleaded and the test was not applied. So I'm not here to persuade you of the answer to that question. Point I'm making is that neither Mr. Makate nor the court addressed that question, and that, with respect, is a fatal flaw. Then my learned friend made an argument which I frankly didn't understand at all, because he went back to what he says we say in our heads about the interpretation of the Concord Order. But we didn't address the issue in our heads at all. It was an issue that we addressed in our main heads of argument in the application. And he says we latch onto the part of the Concord Order that said that the CEO had to determine reasonable remuneration, but we ignore the fact that it also said in the body of the judgment that the parties agreed that Mr. Makate would get a share of revenue. That whole debate was a debate in our old heads of argument. And when we dealt with it, we dealt with all of it. We didn't merely focus on the one and not the other. We dealt fully with the proper interpretation of the Concord judgment. We did so in our old heads. If I may just give you the reference, I'm not going to go there, but it's at 125-7, paragraphs 4 to 11. And the essence of it is that the Concord said that the CEO must determine an amount of compensation. It also said that there was an agreement that he would get a share of revenue. Our learned friend then jumps to the conclusion that it meant merely a debate about percentage share, but that is not so. What had to be determined was an amount of compensation in 2001. That amount would be based on a share of revenue, but a share of revenue can mean anything. And let me exaggerate just to make the point. It can mean 1% for 1 month, or it can mean 50% for 50 years. That is what a share of revenue means. And to say that it somehow predetermines the outcome of that exercise, of the amount that had to be determined, is with respect unjustified. And then my learned friend engages in a debate on how a CEO should have gone about it in 2001 and what he should have said about this idea and how promising it was. And my learned friend then concludes that he shouldn't have come to the conclusion that a 5-year contract is a generous one to postulate in 2001. But that is to step into the shoes of the CEO and to arrogate, to take away from him the very function that the parties entrusted to him precisely because of his experience as CEO of Vodacom. He knows better than our learned friend with respect does of how a CEO would have assessed this issue in 2001. And it's simply not open to us today to re-debate that issue as if we know better than the CEO. That was why the parties appointed him. Now, on the question of the 27% and whether all of it should have been allowed, or only 30% as the CEO held, or 0% as Vodacom contended, my learned friend says, and I quote, we, i.e. his side, we considered the 27% to be incremental revenue. But that's not so at all. You may merely look at those debates to which I referred you, in which my learned friend accepted that one couldn't calculate which part of the 27% constituted revenue, but contended that it would be a fair proxy to assume. But let me just read you again 2 sentences that I read this morning, where he said, the next question you asked me is, would Mr. Makate be entitled to incremental revenue? And I assume the question is only incremental revenue. And as a matter of logic, of course, I think that must be correct. The difficulty is to calculate it. And there is then a debate as to how much of the 27% should be allowed. And he concludes by saying all of it should be allowed. It's a fair proxy. He says it's not perfect, but it is the best we can do. So there was an intense debate about how much of the 27% should be recognized as incremental. To suggest that they always asserted that all of it is incremental is, with respect, not what happened. So we submit, milady, with respect, that the question before you as to whether another court may come to a different conclusion must be positively answered because of the debates there is to be had about the basis on which this court came to that conclusion, least of which that the court applied administrative law review grounds when we submit with respect that those grounds are excluded by the Becker test. Milady, we owe you a note on the paragraphs in the judgment on which we rely, or to which Mayor J referred, and we will let you have that in the course of the day.
Thank you so much, Mr. Chief.
Thank you, milady.
Okay, in the circumstances, our ruling will be reserved. I'm going to try as best as I can before I start my duties to get this issue out of the way. So I'm giving myself sometime next week to hand down my ruling with the reasons. So you'll know shortly.
Thank you, milady.
Right, so my ruling is duly reserved and it will get out to the parties sometimes next week. The probabilities are that you would be contacted when the matter is going to be uploaded on case lines, the ruling. Thank you. And thank you for the heads of argument. I'll just await that reference from Mr. Chief. But everybody, go well and enjoy part of the recess. Thank you.
Maybe before David joins, good morning. We do have the reference for the learned friend from the judge.
Okay, Mr. Solomon.
It's paragraph 15. We could share it on the screen, paragraph 15. Just share it quickly. So my learned friend, Mr. Crengrove, is satisfied that is the reference that's applied.
I would, could your ladyship just note the paragraph 15? If I have a different view, we'll come back to you.
Yes, yes. I'll leave that open up. I've just noted it on your heads of argument. Look at paragraph 15, but to revert.
Thank you, Malay.
Right, thank you so much. You all excused. Thank you.